Welcome again to Team Psych Mind in Minutes. I am Tim Godho, a psychologist and coach in Nairobi, Kenya, and a member of the Kenya Psychological Association. With me here is Dr. Naomi Njuguna. We've had her before, and during that time, we had a very interesting conversation about suicide and the law. We shall continue with it. Last time we talked about the current law as it pertains to suicide, and you could give us a brief recap of that as we go to the implications of the new law. So, Dr. Naomi Njuguna holds a Bachelor of Laws and a Master of Laws degree, as well as a PhD from both Manchester University and Leicester University in the United Kingdom. She does a lot of work. She's a senior lecturer at the University of Nairobi Faculty of Law. She teaches health law, law students, and medical students, and she researches, publishes, and is also the chair of examinations at the University of Nairobi Parklands campus. That's the Faculty of Law. We are very pleased to have you again, Dr. Naomi Njuguna.
Thank you.
Thank you for coming and shedding light on this very important subject. You may introduce yourself again for the sake of those people who may not have watched the first episode, and then let us dive in and hear more about suicide and the law.
Thank you. Thank you very much, Tim, for having me again. Hello, viewers. As Tim has said, my name is Naomi Njuguna. More to what he has said, I'm also a mother and a certified professional mediator, mediating in health and labor disputes. And so I'm really honored to be here to continue this conversation from where we left off last time. Just maybe to go right into it, I think last time what we talked about is the current legal environment with regard to suicide and attempted suicide. And what I said and made mention of was the recent court ruling that was delivered in January of this year by Justice Mugambi, a watershed moment in the legal framework regarding suicide. And as a result of that, Section 226 of the Penal Code, which had been used to charge persons with attempted suicide, was declared unconstitutional. This court case is popularly known as E045 of 2022, a constitutional petition that was brought by the Kenya National Commission on Human Rights, as well as the Psychiatric Association of Kenya was involved. And they were petitioning really the court to look at attempted suicide not as a crime, but as a mental issue, a mental health issue. And indeed, what the court said, considering all the arguments that were made, the court agreed and went ahead and declared Section 226 unconstitutional. But it also said that, based on the current, provisions of the law, particularly the Mental Health Amendment Act, which defines a mental illness as including suicide ideation and suicidal behavior. So the court was satisfied that we should not criminalize attempted suicide, but should deem persons who attempt suicide as having a mental illness and should be then treated. Of course, I may have very many questions with regard to that blanket, categorization, of anyone who is having suicidal thoughts or ideations, or even who attempts suicide as somebody who suffers from a mental illness. Because number one, a mental illness needs to be diagnosed by a qualified and professional mental health practitioner. And I don't think that in all cases where somebody has had these suicidal ideations and behavior, one would, categorically state that the person has a mental illness. And so that is where I think further conversation needs to be had. Because what the court was arguing is because of that mental illness, therefore, they do not have the mental capacity to form the intention to actually, want to die by suicide.
Okay.
And therefore, in law, we say they don't have the mens rea. The mens rea means the mental intention to actually formulate the crime itself.
Okay.
However, I question that because I think the issue of mental intention for purposes of determining whether somebody wants to commit a crime and the mental capacity for purposes of knowing whether somebody can make a decision are two totally different things.
Yeah.
And it's not necessarily hinged on whether somebody has a mental illness or not.
And that touches on the philosophical point you made earlier.
Yes.
Of autonomy.
Yes.
You made in our earlier interview.
Yes.
So what difference does it make? Because of whether we can identify that the person had a mental illness that was diagnosed or can be diagnosed, or they didn't have.
So the difference is in two instances. So we've talked about what the court said with regard to the criminal liability of this person.
Yeah.
And what the court has declared is that this person should not be criminally liable.
Yeah.
Because they don't have that mental intent.
Because
they are suffering from a mental illness.
Yes.
But then the other part of it is now for medical decision making. And when this person, is receiving treatment or should receive treatment, and whether they can even be forced to receive treatment and things like that.
Okay.
And I think the spirit of the Mental Health Amendment Act of 2022 is moving away from what is called a biomedical model of looking at a person with mental illness and looking at an integrative approach. Now, what does this mean? It means that you want to, in fact, the Act says that this person is a human being who should be accorded the same dignity and the same rights like any other person. And so when it comes to their decision making for purposes of treatment, there's the question of consent. And the law actually says that their consent should first be obtained.
Okay.
Now, for consent to be obtained, it means they have the mental capacity and they have age capacity, meaning that they are adults and they can understand what is happening. So not all mental illnesses, according to what the Act is then presuming, is that not all mental illnesses take away the ability of a person from making decisions or from understanding exactly what they are doing. So I think, from a lawyer's point of view, we need to have a further and deeper conversation as to the distinction between mental capacity for criminal liability and mental capacity for medical decision making, so that we don't always assume that having a mental illness and therefore not being criminally liable means that you also lack autonomy to make decisions for yourself medically. Yeah.
So the question of autonomy comes in. I think the spanner is in the works.
Yes.
You have put one, I have put one. I put the spanner.
Yeah, sure.
What is happening in other parts of the world in terms of autonomy, being able to decide? Because here is our law now, which says that everyone who attempts suicide will be considered mentally sick. And if, for instance, unfortunately, there is stigma around mental health, they would be subject to the same stigma as those who are mentally sick, and we are trying to get rid of that stigma. So what is happening? What is the conversation with regards to autonomy
Yeah.
Here and in other parts of the world?
Yeah. So let's start with here. I think, as I said before, there's actually that disconnect between what the Mental Health Amendment Act is providing and what the court actually, gave that blanket, kind of declaration, diagnosis, if you want to put it. Because this act is in keeping with international standards, that persons with a mental illness should not be stigmatized, should not be discriminated, should not be treated as people who are completely unable to make decisions for themselves. And so even when it comes to issues such as, coercive treatment, where, you want to either restrain them, or you want to put them in seclusion, or you want to sedate them, which we have seen. I think that has been the practice. This law is now saying those kinds of, methodologies should be like a last resort. When you find that the person is in a situation where there's imminent danger.
That's right.
Or immediate danger of them harming themselves or others. And, the treatment that you want to give them cannot be administered in any other way.
Right.
So it should be a last resort, and the autonomy is respected because they are supposed to give consent. Even in admission, they should give consent. Unless, there's that aspect of involuntary admission, where the supporter, the representative, and in the case of a child, the guardian, is consulted so that this person can then be admitted. And a person can also voluntarily admit themselves. Yeah, so the issue of autonomy, I think what I'm trying to say is that the current move is in keeping with international standards of respecting the autonomy of this person and integrating them rather than institutionalizing. Integrating them into the community, try to treat them with outpatient services more than inpatient or institutionalization. So there is actually a move to recognizing the autonomy of persons with mental illness.
Good. Let's move to the wider society.
Sure.
We have a court position that says now it is not a crime. And out there, the courts, the police, and the public have used it in the handling of people who had suicidal ideation or who were known to have attempted or were going to attempt. How we talked earlier about communicating this, but what is the scenario now with the chief, the police, the members of the public who find someone in the marketplace? What does it look like?
So I think what your question, it begs a lot, because there is what has been happening and the approach that say law enforcement, community members, healthcare practitioners, there's the approach that they would have taken towards a person who has suicidal ideation, or even who has attempted to die by suicide. So there's what has been happening, and I think there are those who are convinced still that this is because of its immoral implications from a religious and cultural point of view, that a person who has such tendencies should still be treated like a person who needs either to be punished, to be deterred, to face consequences for this particular action that is intended for self-harm. But then there are others who are more sympathetic and actually realize that there could be factors that are pushing this person towards those tendencies. So from this ruling and from the way that the act is, taking us, and of course, governmental strategies like the suicide prevention strategy, the mental health policy, which actually deems this as a disability. I think there needs to be more sensitization.
Okay.
And the sensitization has to be a sectoral collaboration of the various players, including the church,
Yeah.
and other religious organizations, from Islam, Hinduism, and so on. We need, and African culture as well, and look at it from a holistic point of view, to see how, education, rather than, getting people to see it in a stigma. Actually, we say, as lawyers, law is a tool of social engineering. I think we saw this during the HIV AIDS, when it was really at its peak, even globally, where when we introduced a law that, made it an offense to discriminate or to test people without their knowledge, or to deny them entry into certain institutions. When you put a law such as that, it now kind of allows people to be free. So it's a tool of social engineering. And it's the same here, that we can use this ruling and the laws around this to re-engineer our social fabric and understanding of suicide and attempted suicide as they should be understood. Yeah.
So what scope is there for getting a person with suicidal ideation and or who has attempted suicide, to get them to receive the right treatment that they require and frankly desire?
Yeah. The scope is quite wide, both within the statute, because the statute actually encourages that the person involved has the right to be involved in their medical decision making. Now, what this then means, it gives health professionals leeway, to, in the best interest of this person, to, not to view them as, completely unable to make decisions for themselves, but to involve them in what kind of treatment plan, and a treatment plan that would integrate them with the normal life. Yeah, not that, I think a lot of people would fear going to mental health facilities because the assumption is that they will be locked in, they'll be locked up. But there is scope now that you want to treat this person as they integrate with the rest of society and their economic activities, and they're not admitted. Yes.
Who may have suicide or suicidal ideation? How will one expect to be treated? By the public, by the administration, but more importantly, by the professionals. And we can see that the professionals have been proactive. You mentioned that this case was brought up by the Psychiatric Association of Kenya, as well as the Kenya National Human Rights Commission. So how can one now expect to be treated differently from what was there before?
I think that's a very important question. And I think it's something that both psychologists and psychiatrists, I think it opens for them a window to now do their job without fear that if they don't report this person, then they would get into trouble. I think it creates, the patient now would have a better environment. What they would expect, to go directly to your question, is they expect that their human rights would be protected. They expect that the institution that they're seeking treatment from would protect their dignity, would maintain confidentiality, except of course where the law allows for disclosure to be made. They would expect that insurance cover would be given to them without discrimination. And so I think there is a higher, it is only maybe the sensitization that needs to happen, but they can expect that. That is what the new framework, the new landscape of this is providing.
Okay.
Yes.
And what's trouble? And the psychologists, psychiatrists, and doctors, or even hospitals, get into if they breach this?
Yeah, that's a good question. So apart from the liabilities under the Act, under common law, there is what is called the duty of care. And duty of care arises when there is a relationship, what we call the neighbor principle. There is a special kind of relationship between the two, say that doctor and the patient, that puts them, it's almost like putting them on notice that the manner in which you treat this person should be up to the requisite standard. And if that standard is not met, and this person suffers harm, then you can be sued. So there is the normal statutory liability, but there's also a liability under this duty of care. So if there's negligence in the way that you treat this patient, even in the time that you take to examine a patient, that can speak to whether you fulfilled your duty or not. The issue of the type of medication, the issue of whether you notice certain tendencies and ignored, that can go towards indicating whether you met the requisite standard of care. Yes, and you can be then sued either by the family or by this particular patient if they are still alive. Yes.
Are there instances where the person attempting suicide or even dies by suicide could attract some liability?
That's an interesting one because aside from the criminal liability, which has now been done away with, if this person destroys property, for example, or in the process of attempting to self-harm, they also harm somebody else, it is possible that they can be held civilly liable or even criminally liable if they say destroy property. And it would not be the most ideal situation to either charge or to sue this person, but it can happen. And in other jurisdictions, I think it has also, happened where a person has been held liable for that.
Very well, Dr. Njuguna. It's getting hot again.
Yes.
But I think we should be going now. Are there some issues, some points you would like to make about the law in general before we go?
Okay. So I think, first of all, I want to say thank you very much for inviting me just to give this panoramic view of the law on suicide. We haven't really gone into too much detail, but I hope that the information given will be sufficient for people to ask more questions and to seek more advice. But this is a word also to our lawmakers. Please hurry up. We need this particular provision in the penal code repealed. We also need regulations that would enable the Mental Health Amendment Act to be well operationalized. And we need to have conversations around many other actions, including technological advances, which are causing our young people to get suggestive ideas on the issue of suicide and attempted suicide. I think the age bracket that is quite high is now between 15 and 29, and there's a lot of social media influence. And so we need to see how content can be regulated to protect vulnerable members of society to move away from suicide ideation and suicidal tendencies. And to all of us, let's hold hands and try to support each other. Give a call. Don't stay silent. Call out for help. help is always there. Thank you.
So I hope some members of parliament are watching. 2027 is not too far away. You can, as a member of the public, you can go to your MP, your member of parliament, and discuss these things and the need to do what they need to do in the law. Thank you, Dr. Naomi Njuguna. You're a very busy person. I don't know how you get time to do anything else, but we are grateful that you would come.
Thank you.
This has been Team Psych, the channel that brings you mental health and emotional wellness issues in plain language. More truth, less stigma, here on Team Psych.